I think that in this case, the probable scenario is the fact that probably at the time when the Terrorism Act was used to charge Nnamdi Kanu to court, it actually existed. That is not a cure for the fact that it has been, once it has been repealed, they should not be charged, under a law that does not exist. The charge ought to have been amended if it is true that the law was repealed. There are other legislation under the Criminal Procedure Act, under the Criminal Code in the southern part of Nigeria, for which Nnamdi Kanu could be charged. He has raised also a fundamental issue that his detention in DSS custody is against the law and against the Constitution. I think he has a point there. If anybody is under detention, it ought to be under the protection of the prison authorities. But maybe because of the fact of the special nature of his own case, where he is alleged to have armed militants capable of springing him from custody, the DSS feel that, and they may have convinced the court that they're in a better position to ensure that he stays in custody and that he's brought to court whenever he's required to be in court. So it now depends on whether it is true that the terrorism legislation has been repealed. If it has been repealed and he has been charged under a non-existent law, the entire case will collapse.